If you served your country, one quiet paperwork mistake could still mess with your gun rights years later. And if your family does not know these 8 forgotten rules, they could either give up rights you still have or accidentally step into a federal crime. Pause. Quick question before we continue. Are you subscribed? Because what I am about to reveal could save you from life-changing legal trouble. Hit that button now and stay one step ahead. Here's what shocked me. Most veteran families think gun rights are simple. You either have them or you do not. But the truth is way messier. A VA decision, an old court case, a discharge paper, a protection order, even a state-issued marijuana card can change everything. And the worst part? A lot of families do not find out until they are standing at a gun counter, sitting in a patrol car, or cleaning out a loved one's safe after a crisis. So let me break this down for you in plain English. First, a VA fiduciary issue does not mean what many families think it means anymore. For years, a lot of veterans believed that if the VA decided someone needed help managing money, that alone could wreck firearm rights. Families heard, he has a fiduciary, and thought, that's it, he can never touch a gun again. But here's the part nobody was talking about. That rule changed in a major way. The VA announced it would stop, automatically reporting veterans in the fiduciary program to the federal background check system just because they needed help with finances. Why does that matter? Because needing help paying bills is not the same as being dangerous. Those are two very different things. Imagine your dad is a combat veteran. He has memory problems. Your family helps him with benefits and budgeting. Under the old way of thinking, everybody panics and assumes his rights are gone. But now, the key question is not, does he have a fiduciary? The real question is, was there an actual legal finding that makes him prohibited? Huge difference. Second, getting mental health care is not the same as losing your gun rights. This one really matters, because fear keeps people from asking for help. Have you ever heard somebody say, don't go to the VA for PTSD, they'll take your guns? A lot of veterans have heard that. A lot of spouses believe it too. But most people think treatment equals prohibition, and the truth is, treatment alone does not. Talking to a counselor, getting PTSD care, taking medication, checking into therapy, none of that automatically means you lose your rights. The federal issue is usually a formal legal finding or an involuntary commitment, not just the fact that you got help. That is a massive difference, and families need to know it. If a veteran is struggling, the answer is not to hide from treatment because of bad rumors. The answer is to get help and understand the real legal line. Third, if a veteran was wrongly flagged, denied, or delayed, there may be a path to fix it. Here's a hypothetical example to explain this. Let's say you go to buy a hunting rifle. You answer every question honestly. Then the store says, delayed. Later, maybe even denied. Your family assumes the worst. They think some old VA file killed your rights forever. But wait, there is something even more important. A denial is not always the final answer. There are appeal paths. Some people can challenge the underlying decision. Some can challenge bad records. Some people who keep getting mistaken denials can even get a special appeal number to reduce future mix-ups. That does not mean every case gets fixed. It does mean you should not surrender based on fear and gossip. Here's what most people get wrong. They confuse problem in the system with permanent ban. Those are not the same. And let me say this clearly. Families should stop guessing based on half-read forum posts and angry social media clips. A veteran can lose rights through one path, keep them through another, and restore them through another. You need facts, not panic. Pause. If you're finding this helpful, imagine what you will learn in my next video about the exact words to use when police ask if you have a gun in the car. Subscribe so you do not miss it. Now this is where it gets interesting, because the next 3 rights are the ones families usually learn too late. Fourth, not every ugly military separation means a lifetime federal gun ban. This is one of the most misunderstood parts of the law. People hear bad paper and assume all rights are dead. But the form used in gun sales asks a very specific question about whether you were discharged from the armed forces under dishonorable conditions. In plain terms, the clearest automatic federal trigger is a dishonorable discharge, or for some officers, a dismissal from a general court, martial. So if your uncle got out with a general discharge or some other ugly separation, do not let the family jump straight to, you are federally banned forever. That is how people give up rights they may still have. At the same time, do not make the opposite mistake either. Do not assume you are clear just because somebody at the range said so. Pull the DD-214. Read the court papers. Get legal review if there is any doubt. Guessing here is dangerous. Fifth, old convictions do not always stay fatal forever. This is the part that surprised a lot of families. Federal law says some convictions may stop counting for firearm purposes if they were expunged, set aside, pardoned, or if civil rights were restored, unless that relief still says firearms are off limits. Read that again, because it matters. In some cases, the paper that took your rights can be changed by a later paper. That means a pardon, a proper expungement, or a real restoration of rights may reopen the door. The same idea can apply in some domestic violence cases too, depending on the exact relief and the exact state law. Most people never look into this. They hear felony or misdemeanor domestic violence and shut the book forever. But sometimes the story is not over. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Sixth, there's also a federal relief path that many families have never even heard of. Under federal law, there is a process called relief from disabilities. In simple words, that means a prohibited person may be able to apply to have federal firearm rights restored if the government is convinced that person is not a danger, and restoring rights would not go against the public interest. And if that request is denied, court review may be possible. Why am I telling you this? Because a lot of veteran families think the law says, once prohibited, always prohibited. That is not always true. Is this easy? No. Is it automatic? No. Can it be denied? Absolutely. But it exists, and families should know it exists before they give up. Here is the bigger lesson. A veteran's firearm future is often shaped by records, appeals, and wording. One phrase on a form can matter more than 10 years of rumor. That is why families who act early usually do better than families who wait until a denial, a search warrant, or a funeral cleanup forces the issue. Hey, 73% of people watching right now are not subscribed. Do not be part of that group. Join the community that gets these updates first, because this kind of information can protect your family before a mistake becomes a case. Let me give you the final 2 rights families wish they knew earlier, because these are the traps that show up in real life fast. 7th, domestic violence paperwork can wipe out rights even when the family thinks it is just temporary. This is one of the biggest hidden landmines. A qualifying protection order can block firearm and ammunition possession while that order is active. Not just buying, possession. And not just guns, ammunition too. That means the old idea of, I gave my pistol to my brother, but I still have a few boxes of rounds in the garage, can still be a problem. Here's what most people get wrong. They think only a criminal conviction matters. Not always. Some protection orders matter too, if they were issued after notice in a hearing and they fit the federal rules. Now, this gets even more serious for military families because some military convictions can also count, including some crimes involving force in a domestic setting. So picture this. A veteran is going through a divorce. Emotions are high. There is a hearing. An order gets entered. The veteran walks out thinking, this is family court stuff, not gun law stuff. That assumption can destroy lives. If you do not know whether an order qualifies, do not touch a firearm or ammo until a lawyer clears it up. 8th, state medical marijuana does not protect you under federal gun law. This one catches veterans all the time. A veteran gets a medical marijuana card for pain, sleep, or PTSD symptoms. The state says it is legal. The veteran thinks, I served my country, I followed my state's rules, I am good. But here's the crazy part. On the federal gun form, there is still a warning that marijuana remains unlawful under federal law, even if a state allows medical or recreational use. So if a veteran uses marijuana and then tries to buy a gun from a dealer, there is real danger there. And if you lie on the form, that creates a second problem. This is where families need to be brutally honest. Do not let someone walk into a gun store with a state card in their wallet and bad assumptions in their head. That is how people end up facing charges they never saw coming. And before we close, let me add one more practical warning that ties all 8 points together. Do not confuse silence with safety. Just because nobody has called, nobody has knocked, and no store has denied a sale yet, that does not mean everything is fine. Have you ever wondered why some people go years with no issue, then suddenly get hit with a denial? Records get updated, orders get entered, old cases get found. Family members say the wrong thing during a crisis. This stuff moves quietly until it does not. Pause. Laws and policies change fast. If you want the next breakdown before the next rule shift catches families off guard, subscribe right now. Staying early is always better than catching up after the damage is done. So here's the big takeaway. Veteran gun rights are not just about the Second Amendment in the abstract. They are about paperwork, timing, exact words, and knowing the difference between rumor and law. A VA, fiduciary issue, mental health treatment, discharge status, pardons, appeals, protection orders, domestic violence cases, marijuana use, and even leftover ammo can all change the outcome. If this helped you, hit subscribe and send this video to one veteran family who needs it. You could save them from giving up rights they still have or from making a mistake they can never take back. And one last simple disclaimer. This video is for education only. Laws are different case by case, and small facts matter a lot. Before you act, talk to a qualified attorney in your state.